I'm glad for the opportunity to be with all of you today. And having heard that extraordinarily compelling testimony from the two members of Congress, we see these are not abstract issues. These are incredibly powerful issues of our time. Let me start with sort of situating this in a longer time discussion. The challenge of where the limits of free speech come and where conduct becomes punishable is not a new issue. I remember one time giving a talk in London, of all places, University College London, and articulating a theory that is roughly like the written testimony that I provided to you that I hope you'll have a chance to review. And a member of the University College London faculty said to me, "Why is this so hard for you? Why can't you just punish people who say things that we all know are wrong?" And I told him, well, that's exactly what it means to be an American. We don't punish people because we just believe what they say is wrong. One of our core principles is one of free expression. There's a reason these are hard cases, therefore, because we are working at the intersection of free speech, one of our core values, but the right to be safe and protected, another core value, and in the area of hate crimes, a third value of personal dignity and equality and inclusion in a multicultural society, such as the one that we are all privileged to live in. And this is nothing new. E pluribus unum goes back 240 plus years, out of many one. This has always been the image of what America is about. So what I would like to do is to articulate a couple of core principles when we look at these challenges, at these problems. I can tell you from working on university campuses all over the country, Phi Beta Kappa has 290 chapters around the country, including many in the Commonwealth of Pennsylvania. University presidents always want to know, how do we react when issues of hate speech or hate crimes come on campus? And I tell them the same thing that I'm sure all of you think all the time in your jobs as representatives. If your way of making decisions is by sticking your finger up in the air to see which way the wind is blowing, it's a pretty bad strategy. Because when these issues are operating, the wind is blowing 360 and it's blowing a gale force wind. So you can't do it by just trying to measure the politics. You've got to have your core principles down. So these are the ones that articulate. First, going back to what we've all said throughout this afternoon, free speech in our society, free expression, is a core principle. Now, what follows from that? That means that we don't start by looking at things that people say and weighing the pluses and minuses, weighing the benefits and the costs. We start instead with a strong presumption that speech should be protected. But it's not an irrebuttable presumption. It's a presumption that does, in fact, have its limits. Now, where might we put those limits? Some people have suggested you distinguish between speech and conduct. You can punish conduct, but not speech. Not a very helpful idea. I mean, think about it. If somebody right now stood behind me with a sign that said, "You all ought to stop listening to Professor Lawrence," is that speech or is that conduct? The answer is really it's both. So speech and conduct is not a very helpful distinction. It's also tempting, particularly in times like ours, to look at the results of what happens, particularly what happened at the Capitol, where in addition to all of the threats to democracy, 5 people lost their lives. But even that becomes a dangerous way to put limits on expression. Because after all, you can't measure in advance what the outcome of expression is going to be. And if you punish speech based on the results of that speech, sometimes what you're doing is punishing the speaker based on what the listener did. The most famous example of that being a problem is what's known in the law as the Heckler's Veto. The origin of the Heckler's Veto goes back into the 1960s, when there were communities, particularly in the southern part of the United States, that wished to prohibit civil rights marches. And they said, if you have a civil rights march in this town, there will be violence. And they weren't wrong, because there would be violence in response to that. But the Supreme Court properly said the answer to that is to put more police protection out to make sure that those demonstrators have the right to demonstrate. So you can't prohibit speech based on the possible outcome. Where should the limit be placed? And this is an interesting place where criminal law doctrine and constitutional free expression doctrine really come together. We look at the intent behind the activity. Is this somebody who was trying to express a view, however hateful, or is this someone who was in fact intending to cause harm, to cause criminal results? When you cross over that line from intending to express views to intending criminal behavior, then you have crossed over the line from that which is protected to that which can be prohibited. For our purposes, there are two main categories, two main instances where this intent allows for criminalization of what would otherwise be expressive behavior. One that we've been talking about today, and it feels as if we've been talking about nonstop for the past 2 weeks, and that is where there is an intent to incite. The Supreme Court has said that speech is protected unless there is incitement of imminent lawless activity. This goes back to a position that was actually articulated in a dissent by my great hero, Louis Brandeis. Justice Brandeis said that in the absence of incitement of imminent lawless activity, the answer to bad speech is not enforced silence, it's more speech. And he was right. Ordinarily, the answer to bad speech is more speech. But people forget the first part of that proviso. He said in the absence of imminent lawless activity being incited. So when you have incitement to imminent lawless activity, that is not protected speech. That has crossed over the line and may be prohibited. The other category I would mention is where the words themselves, the expressive behavior itself, is designed to threaten or to terrorize somebody. You could think of that as a verbal assault. The fact that it involves words doesn't make it different from any other kind of threat or any other kind of terrorizing. So words can be used to threaten and instill fear on an individual, not hurt somebody's feelings, not challenge their politics, but actually threaten them. And when that happens, that too has crossed over the line. Finally, let me address a special context in which these issues present themselves, and that's in the context of bias-motivated violence, or more popularly known as hate crimes. My written testimony lays out at some length, and I will save time here now in the late part of the afternoon by not going back through that, what the case is for why bias crimes should be punished more severely because of the harm that they have on the individual victim, on the target community, and on the society at large. Expression of hate and expression of hateful views should be protected when it is not intended to do harm, which is to say when it is intended to express views. That's what we mean by hate speech, and the answer to that is more speech. But hateful expression that is intended to threaten or incite, that is not protected speech. That is, in fact, classically what's meant by a hate crime. I know there was testimony earlier about the efforts that have been made to expand the definition of a hate crime under Section 2710 of 18 Pennsylvania statutes, your ethnic intimidation statute. I would commend that to your close attention. Pennsylvania, I would say at this point, is behind the curve with respect to adding gender, sexual identity, and sexual orientation to its hate crime statute. So that may be another issue for another day, but I would strongly recommend that you and your colleagues in the Pennsylvania State Legislature think of bringing the scope of the Pennsylvania Ethnic Intimidation Statute up to the level of, for example, the Matthew Shepard Act, which I was privileged to testify about and was privileged to be at the White House when President Obama signed it into law in 2009. Thank you, Mr. Chairman.
And thank you. Thank you. Representative Cerisi, first question.
Yes, thank you very much. It's a very interesting testimony, and thank you for taking the time to be with us today. So we've seen many of our colleagues, the Republicans, have claimed fraud and authored a letter about it, signed an amicus brief, and even passed a resolution to evaluate the elections without any evidence of fraud. What do you feel is the impact of this constant work to undermine faith in the election in the communities who have hateful narratives?
I think the danger of such expression is clear. It may not be one that gives rise to a criminal prosecution. That may be asking the wrong question. Are they guilty of a crime? Sometimes, actually, when we ask the wrong question, we really get the wrong answer. Because what you really want to know is what should be the response. And the response should be an outpouring from people who believe in democratic institutions, that members of all parties, Democrats and Republicans, should believe in the basic democratic system. I'm not being naive here. You're not going to persuade everybody of that. But I do believe that there are people who are watching right now to see which way the wind is blowing on this issue. And we, all of us, as citizens, and you all as members of the state legislature, have a deep obligation at this time to show that it is unacceptable for members of public life to question the very fundamental role of democracy and the way in which the expression of the electorate's vote is counted.
Just a quick follow-up. I'm sorry, Chairman, if you'll allow me. How would you handle this then as a legislator when you have these members who we've served with do this? I mean, if there's nothing legally we can take, we can come out and condemn them, but will we not incite more of the base that supports them to come out and do whatever they feel is proper, or have them, go to the extremes?
At some point, these are crossing over into political questions that you probably know more about than I do, but I would say that efforts to proceed down the line of a criminal prosecution that is unsuccessful will likely do even more to inflame a base, and then ultimately even run the risk of making some of your supporters feel as if you've gone too far. So I would focus on this particular issue where they have worked within their right to express themselves, but what they've expressed is been reprehensible. Not everything that's wrong is criminal.
Thank you.
Thank you, Representative. I have a question. Have you reviewed the speech given by State Senator Doug Mastriano?
I have.
Okay. So in your opinion, does that speech contain any of the hallmark language or illustrate any of the biases that you spoke of today?
I got to say it's right to the line. In my prior life, like Congressman Lamb, I was an assistant U.S. attorney. I was an assistant U.S. attorney in the Southern District of New York in the 1980s. So evaluating this as a criminal case, I regret to say that it's tough because the language is problematic. The language clearly was consistent with illegal behavior. Did it literally have the intent to incite illegal behavior? It goes right to the line, but I'm not sure it crosses over that line.
But you would agree then that lines were blurred and that behavior is absolutely unbecoming of any elected official.
Absolutely. Let's be clear. I would like to think that when I evaluated my member of Congress or my member of the state legislature, the standard I would hold that person to is not has he broken a law. I'd like to think the standard is a little higher than that. So the fact that this may be short of actually breaking the law doesn't mean that you all don't have some right to say that we hold ourselves to a higher standard. I mean, I remember taking an oath when I became an assistant United States attorney. All of you did too. And only people who've never taken that oath take it lightly. Those of us who've taken that oath know what it means when you say that. Protect the Constitution of the United States from all enemies, foreign and domestic. I hope this doesn't sound corny, but I still choke up when I say that. So, and that's how you're supposed to feel. So when people violate that oath to the laws of the Commonwealth, it may not be criminal, but that's not to say it's praiseworthy or even acceptable.
So yeah, that oath is very important, and we cannot mistake that oath for some half-baked version of patriotism that some of these folks, not just in Pennsylvania, but nationally, like to beat the drum with. So again, I appreciate your testimony. And Representative Baczynski, you're up for a question.
Thank you very much, Mr. Chairman, and thank you, Mr. Lawrence, for your testimony. I'm going to put you on the spot because if you heard me earlier, I was talking about people like us who have taken oaths and who knowingly mislead the public by false information or lies. Since you mentioned that intent was a part of something that would be criminal, what I'm suggesting here is that every one of these perpetrators, whether it be on a state or on a national level, be put into a court of law to try to help decipher what the difference is between those that intended to actually invade the Capitol, as they said, hang Vice President Pence and abduct Nancy Pelosi. Difference between them and just some people that may be a Trump supporter that went to Washington just to check things out. I'm very concerned that if there are no consequences that result after everything that's gone down, it is just the pathway for further violence, further malcontent, further misinformation and lies, which unfortunately will then end up in more deaths. I'm putting you on the spot now. So I think it's pretty clear. I think there needs to be hearings. I need investigations with all of the members that we believe violated our oath, and certainly on a national basis. I think there's plenty of evidence for that. If you would, sir. Thank you.
In part, the challenge you're running into is the one that always comes up, for example, in proving perjury. Perjury is a deceptively hard crime to prove, as most of you probably know. Every time somebody lies, it's not enough for perjury. There has to be knowledge that you're lying. There has to be the purpose to evade, the purpose to mislead. Now, to come to your question, I think that there is at least cause in many of these cases that we've been discussing this afternoon that is worthy of investigation of this. And the likelihood of there being no consequences, it seems to me, ought to and should be zero. Let me put that in the positive. There is no justification for there being no consequences out of what we saw. We saw what happened on the Hill, most of us on TV, some of us in person that we heard from this afternoon. Those people are certainly, many of them have crossed a line. Any particular individual, that's what the law enforcement process is for. But it seems to me impossible to imagine that there should be no consequences out of this.